Hello everyone, I'm Akash Srivastav, and in today's Law Wednesday session, we are going to discuss a very important and interesting topic, that is bail laws in India. So let's start the session. So I am very sure that everyone must have heard about this term bail. You must have read about it. You must have seen a lot of movies in which this particular term is used, and you have a very brief idea of what exactly it means. So in today's session, we are going to discuss what exactly bail laws in India are, under which act it is governed, and what are different types of bail. And in end, we will be discussing about one of the most important judgment related to bail. So, as you all know that bail is an instrument for procuring the release of a person from legal custody. So, this is an instrument, this is a means by which a person, if arrested or if it's in a legal custody, then it is released. And again, it is also an undertaking that he shall appear at the time and place designated and submit himself or herself to the jurisdiction and judgment of the court. So, it usually happens that even if you are getting released from a legal custody and if court wants that you should be present before them, then in that case, this also ensures that you are giving a surety, you are giving a guarantee that you will be present whenever it is required by the court. The practice of granting bail grew out of the need to safeguard the fundamental right to liberty. As we all know that according to Article 21 of the Indian Constitution, it guarantees right to life and personal liberty. To ensure that personal liberty is given to everyone, this particular provision have been added under CRPC. So this is the general understanding of bail. Let's move ahead and discuss in which particular provision it is given. So it is mentioned, laws related to bail is given under Chapter 33 of CRPC, that is Criminal Procedure Code, and Section 436 to 450 governs the bail laws in India. So one important question or one common question that may arise to a lot of students, that where exactly bail is defined. So according to section 2A of CRPC, bail is not defined, but bailable and non-bailable offences are defined. So this is basic about the bail, but there is also very important concept that you should be aware of, because you know that if you want to apply for a bail, you are already in the custody. How exactly you will do so? So for this, a surety comes into picture. So the person who pays the money or undertakes a money bond acts as the surety. So whoever is paying that particular money on your behalf so that you can get bail will be known as surety. He can be anyone who is financially worth the monetary condition in the bail condition. So it is very important to know that it is not mandatory the person who is acting as a surety or who is giving money on your behalf needs to be your relative or friend or someone. So according to the laws in India, he can be anyone. So there is no rule as such. So this is the basic about bail laws. Now let's move to which all offences are known as bailable offences and which are categorized as non-bailable offences. So the general understanding is that all those offences which are less serious in nature will be termed as bailable offence. So in all those cases, so it may be crime also, it may be your civil wrongs also. So if the punishment defined for that particular civil wrong or crime is less than 3 years, in all those situations, you can get a bail. But again, this is a general understanding, this is a general law. There are few specifications, few exceptions also. So as you can see that they are considered less serious, hence the punishment is less serious and the accused has a legal right to request release on bail. Generally, these forms of crimes are punishable by less than 3 years. So you need to keep this in mind. A very brief idea, if you find any particular civil wrong or law and you are not very sure whether this is a bailable offence or non-bailable offence, so if the punishment defined for that particular offence is less than 3 years, then it will be usually a bailable offence. So these offences are shown as bailable in the first schedule. So the first schedule of CRPC describes all those offences which are bailable in nature. Few of the examples are simple hurt defined under section 337 of IPC, bribery defined under section 171E of IPC, public nuisance, death by rash or negligent act. So these are few of the examples of bailable offence. Now let's move to the non-bailable offences. So these offences, as I said, that all those offences which are less serious in nature will be termed as bailable offence. So it itself defines all the crimes, all the civil wrongs which will be termed as non-bailable. So which are serious offences, serious in character as opposed to the offences that are bailable. So the sentence in this case in the case of non-bailable crimes is 3 years or more. So in this particular thing, we got to know that if the punishment defined for that particular crime is 3 years or more than 3 years, then it will be non-bailable offence, and if it is less than 3 years, then it will be termed as bailable offence. Few of the examples of non-bailable offences are murder, defined under section 302 of IPC, dowry death, 304B of IPC, and child abduction. So these are few of the examples. There's a long list of non-bailable as well as bailable offences. Let's move ahead and discuss few of the other rights, few of the other things. So one common question that may arise in the minds of a lot of people, that is bail your right? Can you claim this particular thing that this is my right and I should be given a bail, I should be released on bail? So in a civil case, obtaining bail is one of the defendant's rights. So in civil case, it is defined that it is your right. Whereas in a criminal case, it is at the discretion of the bail granting authority. So it is at the discretion. They will decide whether you will be getting bail or not. So that is competent courts or the police officer in charge. These are the two competent authorities who will decide whether you should get a bail or not. So it is as per their discretion. So in civil cases, you can claim bail as your right, but when we talk about criminal cases, this is at the discretion of the authority. Let's move ahead. There are few categories of bail. So the first one is mandatory bail. So you must be thinking that if it is at the discretion of the authorities, then which all offences, which all situation will make this as a which will be termed as mandatory bail. So it's very simple that if any particular set time limit is defined for the investigation process. So if the process is not getting completed within that time limit, then the person will be released mandatory. So there will be no exception to it. So you can be released mandatory and you will be free to go if the investigation, the time limit defined for the investigation have exceeded. If the authority have not been able to complete that particular process within time limit. So according to section 167 of the CRPC contains a mandate that if the investigation is not completed within the stipulated maximum period, the accused is to be released by bail, on bail, whatever may be the nature of accusation against him. So it doesn't depend whether for which particular crime you have been arrested or for which particular crime investigation is going on. According to section 167 of CRPC, if the investigation has not been completed in a due time that is defined under CRPC, then the person will be released on bail. That will be termed as mandatory bail. Next one is interim bail. So this is also a very interesting bail. So this bail is provided as a temporary measure and is valid only while an application is going on when the court is considering an application for anticipatory or regular bail. So if you have applied for a regular bail or anticipatory bail to a court, for that period an interim bail can be released. So if you are already in custody and you have applied for regular bail, in that case court may release you on temporary bail. Okay? The accused loses his right to be free and will be taken into custody if interim bail expires before he is given regular bail. So in case you have applied for regular bail and interim bail have been given for say 7 days. So if within 7 days you get a regular bail, well and good, then you will be out of the custody. But if regular bail is denied, then again you will be in the custody because your time for the interim bail have expired. And he fails to pay the required amount to extend the bail. So in that case also he will be under the custody if he is not able to pay the required amount of the bail. Interim bail is always conditional. So few conditions will be attached to the interim bail by the court and or the authority and can be prolonged. It can be extended also. So for initial period it was given for 7 days. It may be prolonged also. So this is the basic features of interim bail. Let's move to yet another very important type of bail, that is anticipatory bail. So all the law aspirants, it is very important topic, the concept of anticipatory bail. This is in news a lot of times. So you must be aware what exactly anticipatory bail means. So it is a type of bail that is given to someone who is in anticipation of getting arrested for a non-bailable offence by the police. So as we discussed that when we talk about offences, it can be bailable offences also, it may be non-bailable offences. So all the serious crimes will come under the ambit of non-bailable offence. Okay. So if you anticipate, if you think that you may be arrested for non-bailable offence, then you can apply in advance for the anticipatory bail. It's from the word itself you will be able to understand that you are anticipating that in future you may get arrested for non-bailable offence. So beforehand only you are going to court, you are going to the authority and applying for the anticipatory bail if you think that you may be get arrested for non-bailable offence. This is an advanced bail mentioned under section 438 of CRPC. So this is the provision under which anticipatory bail have been defined. An application for anticipatory bail can be heard both by the Court of Session and the High Court. So these are the two authorities that can hear the application for your anticipatory bail. So again, I will summarize anticipatory bail. It basically means that if you are anticipating that you may get arrested for a non-bailable offence, you can approach Session Court or High Court under Section 438 of CRPC and can apply for anticipatory bail. So these are few of the very important bails. Moving ahead, guys. Now, this is one of the most important landmark judgment that happened in 2021. So the name of the case is Satyendra Kumar Antil versus Central Bureau of Investigation. In this case, court guided what exactly should be the criteria, what exactly should be the approach of courts while granting bail or denying bail. So in this case, Supreme Court remarked that jails in India are swamped with under trials because a lot of under trials are going on and the jails are filled with that. Person are arrested and kept in custody. So it emphasized that bail is the rule and jail is an exception. So usually court, if they are applying their discretion in granting bail or denying bail, then the rule should be that you should give bail to the person. And in exceptional cases, jail is the correct measure. So this is what Supreme Court of India said and urged that the government to think about enacting a bail act specifically. So all the rules and regulations regarding bail as of now, it is defined under chapter 33 that covers section 436 to 450 of CRPC. But in this case, Supreme Court emphasized that there should be a separate bail act which will be governing all the provision related to bail to make the process of granting bail more efficient, because nowadays it's on the basis of the discretion of the courts and other authority, and resultant is that a lot of jails are filled with the under trials. So taking into consideration all the facts, all the data, Supreme Court in Satyendra Kumar Antil versus CBI case guided that bail should be the rule and jail is an exception. With an abysmal low conviction rate as a backdrop, the top court also harshly criticized lower courts for how they handle bail application. So they have taken this particular concept, this particular procedure very strictly. So they have said that bail is the rule and jail is an exception. That should be followed by, that should be the correct approach whenever you are discussing, to all the courts whenever they are discussing about bail application. So in today's session, we discussed about bailable offence, what exactly bail means, then bailable offence, then non-bailable offence, then few types of other whether it is a right or not. Then we discuss about what are anticipatory bail, mandatory bail and interim bail, and in the end we summarize this particular session by the landmark judgment which tells all the court that what exactly should be the approach while discussing with the bail application, while dealing with the bail application. I hope the session was informative enough. Thank you everyone. Have a nice day.